Good morning. I will be presiding over this morning's oral argument. To my right, I have Justice Brissett. To my left, Justice Spears, and we welcome you to the Fourth Court. I'm going to call the case at this time, 424-279 CR, John Stephen Meyer versus the State of Texas. I'll take announcements at this time.
Charlie Baird and Mark Stevens on behalf of Mr. Meyer.
Hank Wilkins for the state.
Very well. So you will each have 20 minutes, and then Mr. Baird, you'll have 10 minutes for rebuttal. You may proceed.
May it please the court, we're here today. I'm going to argue point of error 1, and then Mr. Stevens is going to argue the remaining points of error as they needed. Of course, we'll be glad to address any questions that the court might have. In order to establish sufficient evidence of possession of a controlled substance, there are two requirements. One is that there has to be actual care, custody, control, and management over the substance, number one. And number two is you have to know the substance is in fact illegal. We believe that the evidence is legally insufficient to prove either of these. Let me start with the second prong, that Mr. Meyer knew the controlled substance was in fact illegal. I'd like to remind the court he was charged with, the conviction is for possession of methamphetamine. He was in fact acquitted of possession of morphine, and I'll talk about that in just a second. But the methamphetamine was in a closed pill bottle in a bathroom, the master bathroom, and there was no proof that Mr. Meyer was ever in there. But Officer Salazar says that he had never seen methamphetamine, and he's a seasoned narcotics officer. He had never seen methamphetamine in this form and in this color. And specifically, that is found at volume 6 of the record, at pages 71 and 72. He said he did not recognize the substance or that its possession would be illegal. The chemist who testified also said pretty much the same thing, that it was very, very rare to have methamphetamine in a color form. And so we think that there is insufficient evidence to show that Mr. Meyer would be aware that this substance in this format of being blue would in fact be contraband. So that's the second prong. The other prong is, as it relates to, did he have care, custody, control, and management over the methamphetamine? There is no proof from any source that he was ever in that bathroom. When the police entered, he was in a different part of the house, and he and 4 other people were detained.
But if in fact we can take his statement that the room was his and the master bedroom was his and the master bathroom is in and attached to the master bedroom, isn't that a reasonable inference?
I'm not so sure that it is, Judge, and I'll tell you why. He said the gun is in my room, okay? I don't know that it's necessarily a reasonable inference that he was aware that the controlled substance, the methamphetamine, was in fact on the counter, number one, when so many other people had access to the house and there was more than one counter in the master bathroom. So I think it's easy to think that even if he was in the bathroom, and there's nothing I don't believe necessarily attributable to him in the bathroom, but if he was in the bathroom, that it was on his counter versus the counter that we think belonged to Miss Yanez. Melissa Yanez was the lady that was seen leaving the premises, and she was later, her vehicle was searched, and a large quantity of both cash and methamphetamine were recovered there, along with scales, I think, in packaging. There was none of that in here. The other thing is, even if he had access to the bathroom, I don't believe that proves more than mere presence, or as Judge Onion used to say in his opinions, more than just being where the action is. If there are other people that occupy the premises, and there were at least 6 other people that occupied these premises, that I don't think it's necessarily that he was the one that exercised actual care, custody, control, or management, or operated with any one of them in a joint fashion as a party to the possession of that controlled substance.
Any scenario where that reasonable inference would apply? So for example, if we had really strong evidence that the only person that owned that only person that used that master bedroom was him, and that master bathroom was solely connected to the master bedroom. Is there any set of facts that you would consider would be sufficient for a reasonable inference?
Judge, I think that that would be an inference. In the case that I would rely upon, I think it's cited in our brief and also by the state, is Evans versus State at 202 Southwest 3rd, 158. And it was written by Judge Cochran in 2006. And in that case, Mr. Evans was the sole occupant of the house, number one. That was a big deal to Judge Cochran, obviously. And secondly, when the police entered the home, they said, "Do you know why we're here?" And Evans said, "Drugs." And then Judge Cochran, in a very thorough fashion, went through and found 5 other affirmative links that made the evidence sufficient. And I believe that opinion had actually been reversed by the Court of Appeals because it was insufficient. But Judge Cochran found that the evidence was sufficient. So I think that if you have that, Judge Brissett, that the sole occupancy is a really big thing, we believe. And we believe that because the reason we have the affirmative links is because we don't want to have what it's been described by the courts as fortuitous proximity. And that's what I think we have here. He is present in a home. In one of the bathrooms, there happens to be methamphetamine that we submit is in a closed pill bottle. So it was not in plain view to him. But we have that because we know that in structures like this, that we have parents and we have children, we have spouses and roommates and friends and all kinds of people that are there. And you can't say that just because that they're present, that is enough to prove beyond a reasonable doubt that he had actual care, custody, control, and management of the property. We would also like for the court to recall that in the affidavit, the officer said Melissa Yanez is the one that is in charge and control of the home, and that John Meyer is simply an occupant of the home. The home, and I've set this out and I've specifically named them, but there were, after Yanez and Mr. Sparks and his companion left the home, that's 3. When they entered the home, the police officers to execute the search warrant, there are 4 people in that home. So there have been 7 people in and out. And also, there are 2 other people that are associated with the residents as a result of their having their pill bottles there. One was the morphine bottle, and one was a gentleman, I think her name was Catherine Landon, and the other one was, I believe, a gentleman by the name of London, and his methamphetamine, I believe, was found in a totally different room than the bathroom. So we believe that it is not, the evidence is not sufficient for that purpose. We would like to also say some more about the plain view. It seems to me that the state's primary argument is that Mr. Myers occupied the home and the controlled substance was in plain view. We dispute that, number one. We believe that the evidence was found in a closed pill bottle on the counter in the master bathroom. And I believe there were 2 counters. And I say that because, number one, there is in the testimony at volume 4, page 75, it's the testimony of Deputy Rios, and he is one of the seasoned police officers that had done this. And he says, I'm questioning him, Mr. Stevens and I tried the case. I said, "What is this?" And I show him Defendant's Exhibit 11. And he says, answer, "That looks like the pill bottle with meth in it, or what appears to be methamphetamine." That's his testimony, okay? This is Defendant's Exhibit 11. This is a closed pill bottle. You can't sit there and say that this was in plain view. First of all, you don't even know that Mr. Myers was in that bathroom when this was there. But you can't sit there and say that this was in plain view, especially when the other officer says, "I've never seen meth in that form before. I didn't know what it was." So we believe that the evidence is going to be insufficient to establish that he knew it was methamphetamine, and that he had actual care, custody, control, and management. There is, one other point I wanted to make, and I believe it was done by Judge Cochran, and this is in her opinion in Poindexter. And Poindexter is 153 Southwest 3rd, 402 at 205.
402? 204?
I'm sorry, 153 Southwest 3rd, 402.
And what's the Penn site?
It was written by Judge Cochran in 2005. The Penn site, Judge, I believe, is page 35. I'm sorry. That's the footnote. I'll find the Penn site in just one second. I apologize for that. I'm sorry. It's 411.
Thank you.
Okay. And it is under item E, the 16th factor, the quantity of the controlled substance. When she is talking about plain view, she being Judge Cochran specifically says the contraband was identifiable upon discovery. The narcotics officer were able to identify it as such on the spot. We simply do not have that here. So we submit that there is nothing here. There's no plain view. We submit that there's nothing here other than mere presence, and mere presence alone, even as the judges have said over the years, even if it is suspicious, even if it is probable, it is simply not enough in a possession of a controlled substance case to sustain the verdict. And I would like to say, in closing my part of this on this point, we think that the verdict as it relates to the methamphetamine is irrational, kind of on its face. Because if John Meyer was in possession of anything, you would think it would be the morphine in his bedroom. And that is the offense for which the jury acquitted him. And that's the bedroom that had his gun, had his ID, and had, I think, some mail. We never have disputed that he occupied the premises. But we think it's irrational for them to say he possessed a controlled substance that nobody could recognize, no police officer could recognize, in a totally separate room, and not find him guilty of
The state talked about the affirmative links rule, which is some of the facts that you were just talking about. There was the master bedroom, master bath, his gun was found there, the ID. You don't think that's enough circumstantial evidence?
No, sir, I do not. And for the reasons I've stated, I do not believe that's sufficient.
Is there any evidence in the record that anyone else occupied the room with him?
There is, yes, ma'am, there is. There's evidence of female clothes being in that room. And the only clothing that was found in the master bathroom, which had an attached closet, was female clothing. And there was some luggage in the bathroom there as well, and it only contained female clothing.
So we know that the master bedroom, Mr. Meyer said that the master bedroom was his. The pill bottle was found in the master bathroom. And I've heard you say that there are two counters there, and it was probably Miss Yanez's counter. But does case law require us to find that he had exclusive possession to make that affirmative link?
I don't believe so, Judge, but it has to have more than just, like I said, being where the action is. It does not have to be exclusive, but certainly this was not exclusive. I mean, like I said, there's at least 7 other people there and 2 other people that are tangentially attached to the residence. And it seems to me like it's perfectly reasonable to think that the methamphetamine on the counter, where there are other, and you can look at these, but there's lots of feminine items on this counter. It's perfectly reasonable inference that this was Yanez's methamphetamine. And she left the house to go sell and distribute methamphetamine, which was what she was a drug dealer, and left some there for her later use. But there's no showing, we don't believe, from a rational basis that you can say that John Meyer, in fact, was aware that it was methamphetamine, or that he actually had actual care, custody, control, or management, either exclusively or as jointly with anybody else in the home.
I know you're going to talk about the relevancy and things like that, Rule 402, 403, 404 later, right? My question is, those facts, if they were to come in, would that be a totality of the circumstances that can only a factor and, the master bedroom, master bath, plus the box and the drugs they found on her, all that together, right? Don't you look at everything?
Justice Spears, are you talking about Yanez and the search of the black Jeep? What we were quick to point out, and the state readily conceded, I think, at trial and on appeal, is that there is no connection, zero, with John Meyer and that vehicle.
No, I understand your argument. I was just asking, do we take that into account of all those facts? Are we just focusing from when the Miranda rights were read on forward?
There are and she did, I don't think she made an incriminating statement that inculpated John Meyer. I don't think there's any connection between that. The vehicle, the black Jeep, was in fact what I believe the informant had notified the police officers of at the very beginning. So there's going to be a black Jeep there.
Right.
Okay. And
They saw her with a box, and then that's the box they found with
Yeah.
the drugs later.
and she came in and out of the house a time or two while it was being surveilled. But they never saw even John Myers get in the vehicle or anything of that nature. So I think the fact that one person in the residence that was under her control, her having possession of a controlled substance doesn't necessarily mean that you can attribute that same possession to John Meyer.
Your time is up. I'm gonna
Thank you.
choose my follow-up.
Was there any other questions?
I don't have any.
Thank you. I appreciate your time.
So that was 20 minutes. Did you want to wait until, or do you want to do the rebuttal now?
I was gonna, was that 20 minutes, Your Honor?
He did. He used
No,
all.
no,
20
no.
Oh, that was 15? Oh, good. Thank you. You have 5 minutes.
Thank you.
I didn't see the 15 at the start. That's okay.
Fortunately, Your Honor, we filed a reply brief, and we think the reply brief fulsomely replied to what the state's points are. But I'd like to talk briefly about point of error 2, the search and seizure issue, in which we say the affidavit was deficient. I told Judge Boyd, and I don't think it's an exaggeration to say this is the flimsiest affidavit I've ever seen in my life. We point out, and that's just not me talking, we point out in detail on page 22 through 37 of our original opening brief, all the deficiencies, paragraph by paragraph in this affidavit. What I want to talk about now, though, rather than rehash that, because they're in our brief and our reply brief, I'd like to talk about the state's brief on this. And because I think the state twice misstates facts. And I know Hank Williams, I've known him well. He didn't do it on purpose. He's not a dishonest man, but he misstated crucial fact in this case, and that is this. In his brief, state's brief, page 20, fact number 7, he calls it a fact. He says, Yanez was stopped for a traffic violation after leaving 224 Majestic Grove, but before she stopped anywhere else. There's no support for that, not one word in the affidavit. It's just not there. And that's what the 4 corners of the affidavit is what the magistrate was limited to. So from that fact, which is not a fact, Mr. Wilkins, the prosecutor, says that from this, the magistrate could reasonably infer that the methamphetamine originated from the residence, 224 Grove, and not from another place, since Yanez did not make any stops before she was pulled over. That inference is no more supportable than the fact, the so-called fact it's based on.
You're saying the fact that was not in the affidavit was the fact that was the assertion that she made no other stops?
That's right.
Okay.
All the affidavit says was she departed the location, and then it says, and then a traffic stop was held. So we don't know where she was. The magistrate, let's put it this way, the magistrate had no basis for determining that there were no stops made. And that's important if they're going to use it for the inference he wants to use it for, that if she didn't make any stops, then whatever was in that, and this is what I wanted to say too about the black box or bag. Justice Spears, you asked about this. This may sound picky, I hope it doesn't. But in the affidavit, it says that the person had a dark rectangular bag or box. And Mr. Wilkins says that then this is a fact, this is the second fact I was talking about, located in the same black rectangular box. Well, it wasn't. A bag is not a box, and a dark bag or box is not a black. Now, that may sound picky, but I think it's worth pointing out. At very least, it is not a fair statement for the prosecutor to say that it was located in the same black rectangular box. Another fact that I don't think is a fact as a matter of law, the prosecutor in his brief points out that Yanez denied permission for the officers to search her vehicle. We cited a case called Lall v. State, L-A-L-L v. State, out of the Court of Criminal Appeals, in which the Court of Criminal Appeals just in the last few years said that the lawful refusal to consent to a vehicle search may not be considered when determining probable cause. Well, if it can't be considered against Yanez, it certainly can't be considered as probable cause to go back and search the residence that Yanez controls. And finally, I don't know how much time I have left, but
50 seconds.
I'll do it then. On pages 8 and 9 of our reply brief, what the prosecutor calls instructive is the case of Flores v. State. And we think on pages 8 and 9 of our reply brief, we point out about 7 reasons why the Flores case that the prosecutor calls instructive is in fact quite different and quite distinguishable from our case. If the court has any more questions about the remaining, I'd love to be able to try and answer them, but out of time.
Thank you. I have no questions.
Thank you.
Good morning. May it please the court. I believe Mr. Baird said I tried this case with them, so it's great to have this opportunity to do this appeal. It's not what I typically do. I'm typically in the trial court. So thank you for having me today. And reading this was kind of like grading your own paper a little bit. So kind of a bizarre experience. But I would like to address today points of error 1, 2, 3, and 4. And then 4, 5, 6, and 7, I'll rest on my brief. So I just want to start by saying this is a very straightforward drug case. And so we're asking that you affirm the conviction. So for the affirmative links, I think the important affirmative links here, which have to be viewed in the light most favorable to the conviction, is the appellant was in the house when it's searched. The contraband is sitting there on the bathroom counter. And I know there's a little bit of argument about whether that's in plain view or not. There's a case, Tate v. State. It's 500 Southwest 3rd, 410. In that case, the court refers to drugs being in plain view when they're inside of a compartment in a car. And they said that that conviction was upheld on appeal. And so I think if there's this argument as to whether the drugs are in the container or not, I don't think that's very material. It's out there on the counter. If it's in that container or not, it's out there in plain view, I think is what this Tate case says. There was also morphine seized as part of the search. Now, he wasn't convicted of that, but that is another affirmative link, I think, that there's other contraband in the house. And when that methamphetamine is seized from that bathroom, there is a big porch that could be used to smoke drugs. I think that's paraphernalia that they're in the house. Melissa Yanez is arrested with a large amount of meth, with packaging and with a scale right after she leaves 224 Majestic Grove. And I want to talk about that in a little bit. But there are security cameras on the house. I think if you look at it's States Exhibit 30 and 29, these are both photos of the bathroom. You'll see that there is clothing that could be worn by a man. And in fact, there are slide sandals that are very similar to the ones that the appellant is wearing in States Exhibit 4.
But are there also, in the pictures, are there also feminine products as well?
Yes, ma'am. And if they're not in those specific pictures, there was testimony at trial that the officers found women's clothing in that bathroom as well. But I think there's also men's items.
So if that's the case, if there's women's clothing in the bedroom and there's women's products in the bathroom, it's reasonable to assume that they shared the space. So what is the fact that links him to the drugs versus her?
Well, I think that's something that the jury had that information in front of them, and I think that's a call that they made, right?
But was there other evidence?
I think that when he makes that statement that there's the gun in my bedroom, he's referring to it as my bedroom. He doesn't say in a bedroom, it's my
Right, but
bedroom.
if the evidence is that they shared the space, you would need, and the jury can make a reasonable inference, but it has to be a reasonable inference. So what other evidence is there that actually proves towards him versus her?
I think that it just being sitting out there, it's his bathroom. I think they can make a reasonable inference that you've got a torch there, you've got these drugs, whether they're on the counter or in the pill bottle. I think that's a reasonable inference, and that's the jury's call. I think they get to decide.
But if they, but do you agree that they shared the space? There's evidence that they shared the space?
There's evidence that there was a woman there, I think, with the women's clothing. Yes, ma'am.
Okay. So you're saying really the only evidence is his statement that it was my bedroom?
Well, it's his statement, Your Honor, but it's also his driver's license with that address is in that bedroom. His mail with that address, so it's his name.
I'm not disputing the fact that he used that bedroom
Yes, ma'am.
and had control of the bathroom. But it sounds like there's evidence that somebody else also shared the space.
Mhm.
So why is it more reasonable for the jury to find that the drugs were in his control versus her control?
Well, I think he's there when the warrant is served, when they search the house. And then there's not any evidence that we know that there's women's clothing in there. There's not any evidence that was brought forth in trial that it was a specific person. So I think that's the links there.
And what do you think about the affidavit where, I mean, it says the premises under the control and charge of Melissa Yanez? I mean, the affidavit says that, right?
Yes, sir. Yeah. I think when they get this tip, then they're watching the house. They see her leave. I think that's part of it, right? That's why it goes in the affidavit. And then it says in there occupied by the appellant. So I think that's, and that was all in front of the jury too, right? This was all in front of the jury at trial.
So you're saying that you can use those facts that we've been discussing, master bedroom, master bath, you're saying you can use those as inferences or the jury can infer, even though the affidavit says she's in control of the premises?
Yes, sir. Yeah. And I think it's a reasonable inference. It is an in-suite bathroom. So he calls it my bedroom. And I think I should clear that up too. He says there's a small pistol in my bedroom. The police didn't recover any other pistols. That's the only pistol recovered is in that bedroom. So it's not as if there's another room he's referring to. And the only way to get into that bathroom is to go through that bedroom. So the appellant received bills there. He registered that address with pretrial services, and that was a stipulation that was introduced in trial.
Sorry, say that again. He registered what?
He registered that 224 Majestic Grove address with pretrial services. So that was a stipulation that was entered at trial. State's Exhibit 32. It says, this is the address that I register with pretrial services. The driver's license lists 224 Majestic Grove as his address. That's found in his bedroom along with the bill that's addressed to him. And I believe this is also, I have a couple more cases here. It's Hawkins v. State is the first one. It's 2018. It's a Westlaw citation. So WL 3264765. That is a Fourth Report case. I think the connections there are even more tenuous than this case, and the court said it was a good conviction. The defendant's not there when the warrant was served, but his ID card and his social are found near the drugs. And this is also a case where men's and women's clothing are found in the house, and they still upheld that conviction. The other case is Torres v. State. This is 2002 WL 287719. Another affirmative links case. I think these facts are actually worse for the state also than our present facts, and this was also upheld. So in that case, Torres is not there when the police serve the warrant. The drugs are found in the kitchen. The postcard with Torres's name and a P.O. box address, those are found in a front bedroom. So a totally different room, very far from the drugs.
Was it also a situation where there were several people in the house?
In that one, so Torres is not there, but there are other people there. And I just don't remember on Hawkins. He's not there, but I believe other people are there too. And then there's a title receipt there also, but I think those facts are worse for the state, and those were both upheld. I would like to talk a little bit about the the motion to suppress, points of error 2 and 3. I don't think the trial court erred on these. There's a warrant in this case, so the burden is on the appellant to prove that it's their burden and they didn't meet it in this case. So I'm asking that you deny points of error 2 and 3. If there's a way to look at this affidavit and say, hey, there's probable cause, the reviewing court is supposed to do that. And so I think the big reasonable inference from the affidavit, if you look at it, well, I guess the first thing I should talk about is this notion of Ms. Yanez. How is the magistrate going to reasonably infer that she didn't stop anywhere else before she was pulled over by the police for that traffic violation? And it's in this, what I think is a reasonable inference based on what's in the affidavit is it says that they observed Melissa Yanez exit the residence. She leaves, she drives about 100 feet, then she turns back and goes back to the residence. Then she exits with a dark rectangular bag or box, and then gets back in her vehicle and departs the location. And the very next line is a PC stop was conducted. So I think it's a reasonable inference that the magistrate reading this, she can say, well, look, he mentioned the only stop she made. She leaves the house, she goes about 100 feet, then she goes back to the house, comes out with this bag or box. There is no mention, and then she stops somewhere. There's a PC stop. So I think that's a reasonable inference based on what's in the affidavit. And I would say that there are lots of things that maybe we wish were in the affidavit, but it's not about what's not in the affidavit. It's about what is in the affidavit. And I think based on the plain reading in the affidavit and then the facts you can find from that affidavit, you can make reasonable inferences that the information was reliable, that about the tip based on the surveillance and Yanez being pulled over with over 300 grams of meth and packaging and a scale. I think it's a reasonable inference that the methamphetamine originated from that 224 Majestic Grove based on her not stopping anywhere else. And so I think that's reasonable based on the affidavit. And then the other thing I would like to address is on point of error number 4, the oral statement. If y'all watch that, that's State's Exhibit 4. And so once the police served that search warrant, the appellant's detained. And I just want to kind of read exactly what it says, just because I think it's important. The language is important. So he's read his rights and he nods his head that he understands. And that's on the video. It's in my brief, and y'all can take a look. And it's also in the trial court's findings of fact. It's number 8 on their findings of fact here. It's although very subtle, this court finds that appellant's nod of his head in response to the inquiry, whether he understood the rights Deputy Salazar just read, was clear apparent. And then skipping down to number 12, this indicates to the trial court that appellant was well aware of his rights. He understood them. He was well aware that he could answer or refuse to answer any question. And so I think it's important here. That part's important, but then it's also important that after he says the one small caliber pistol in my room, the officer asks him, okay, is there anything else? And at first he doesn't respond. And then he says, yes, I don't know. But I think that's indicative that he knew what his rights were and he was waiving them voluntarily with that nod. And also even without the nod, even if there is no nod, he knows that he's able to answer some questions and not answer other questions. I think that's pretty clear from the video.
So you're saying we don't need to see the nod?
I don't think you need the nod, but I think there is nod. But I think even if there was no nod, we'd be okay.
Barely perceptible.
Yeah, I agree. You can zoom in a little bit. It makes it a little easier. But so there's also no evidence of like intimidation or coercion.
So you're saying because he mentioned the gun, but he failed to mention the drugs, you're saying that makes it where he understood that he can remain silent?
I think that's something that y'all can consider. That I think that makes it, I think that's an indicator that he knew he didn't have to answer questions.
But doesn't it also go against you when he said, because they asked him, were there drugs? And he said, I don't know. And the defendant's saying there's nothing linking him. It could have easily been whoever was sharing the room with him. And he says, I don't know. Doesn't that work against your argument?
I think that's also something that it's in front of the jury, right? So, I mean, because in front of the jury, they see the whole video and they're allowed to say, they're the exclusive judges of the credibility of everybody. And so they look at that and they say, I don't find that statement credible. I think that's up to the jury.
Yeah.
And so, I think just none of this evidence belongs in a vacuum. You got to look at that totality there. So we're asking that you affirm the conviction.
And you wanted to rest on your brief on the others, but just real quick, can you tell me about the 402, 4443, the balancing? And really what I want to know is the character evidence component. They're saying that the extraneous offense and her statements are attacking his character only. What do you say about that?
The statement that,
When she got pulled over, they're saying that that was attacking his character, that the statements she made are leading the box back to the house. That's what they're arguing, right?
so I think they're saying just any mention of the traffic stop with Melissa Yanez should be out of bounds. I think that those 3 points of error, that's what they're saying.
Right.
She doesn't really, my recollection of that traffic stop, she's not really saying anything. It's not her statement that would be, I don't recall a statement that she makes that hurts the appellant. It's more just the traffic stop and then what they find in her car.
Oh, I don't have any more
No,
questions.
okay. Thank you.
Thank you. You have 10 minutes, Mr. Stevens.
Real quick, can you just tell me about that character evidence?
Yes, Your Honor. It's our belief that they use it specifically, and it was certainly something the jury could have taken as character evidence for John Meyer. They're trying to associate him, basically guilt by association, and say that, and I think the prosecutor even argued it. And what I'd like to do is be able to go back and find that reference and cite that to the court where they argued it. And the argument was she had 300 grams of methamphetamine, cash, and they argued that that's one of the reasons John is guilty. So that's why we think it was, not only does it not show he's guilty, it's irrelevant, but it's highly prejudicial, basically relying on the guilt of a third party. And by the way, Justice Spears, there was no charge of law of parties here. That was not submitted to the jury. So the jury had to
The
find.
proper character is not relevant, and under 403, it's prejudicial.
And also inadmissible under Rule 404B because it's just character.
No, thank you. I appreciate that.
Thank you. As to the affirmative link, Your Honor, Mr. Wilkins talks about the torch. It's a construction site. There's no doubt about it. The police mentioned that. The house was a mess. So the fact that there is some torch not linked in any way to John Meyer doesn't prove anything. That they have security cameras on the house, well, that would implicate a lot of people. I think that's a stretch. I think that's indicative or emblematic of the various stretches they're making in this case. I'd like to talk about their cases. And I'll tell the court, I looked at 82, I think it was 82 cases from this court, going back as far as I could go back on the affirmative link doctrine. And I can't find a single case out of this court, published or unpublished. And I want to talk about the cases he cites out of this court, which is close to our case, which has so few affirmative links as ours do. And I can't find any case out of the Texas Court of Criminal Appeals that helps his position because it's distinguishable from our case.
Are you familiar with the Hawkins?
Yes, I am, Your Honor. I'll talk about that right now. Justice Rios wrote that opinion. In Hawkins, there were several hand-to-hand transactions that the police observed at this location, at the Hawkins location, that were indicative of exchanges of narcotics. There's nothing like that here. The CI, the confidential informant in Hawkins, purchased drugs from Hawkins in the very apartment that the drugs were found in the day before the warrant was executed. Nothing like our case at all. Did I answer Justice Brissett that question? Let me talk about some of his other cases. He talks about the Tate case, easily distinguishable. They're in a car or truck, and the methamphetamine is found in the center console in plain view with a syringe in the console of a truck that was owned by the defendant. There's no question, there's no evidence of ownership in this case. And as Justice Spears pointed out, their affidavit says Yanez was in control and charge of the premises. And furthermore, in Tate, so those are the affirmative links in Tate that aren't here. Plain view is very contextual, I think. You think of plain view ordinarily in terms of a search. So if a policeman comes in and they look all around the apartment and they find some drugs in plain view, they can seize that. That's plain view in that context. But we're not talking about that. We're talking about plain view as an affirmative link. What that means, I think, is that there has to be some evidence or even an inference, a reasonable inference based on evidence that the defendant, that the drugs in question were in the defendant's plain view. A couple of points on that. Yes, and by the way, we don't dispute the fact that he occupied the premises or the bedroom because of the statement and the documents found. But the question is, how do you get from the bedroom to the bathroom based on plain view? We've talked about women's and male products, clothing in there, but this search happened at 5:30 in the afternoon. Where was John Meyer at 5:30 in the afternoon, or 4:30 in the afternoon, or 6 o'clock in the morning? The fact that there were 6 other people associated with that house immediately, and by the way, 2 other names on pill bottles, so 8 people associated directly with that house.
But you would agree there's a difference between a bathroom that is solely attached to one bedroom and a guest bathroom that is used by more than one person.
Yes, but I don't know that we have the solely attached, but we don't have any evidence at all of who did or did not use this bathroom.
And you're saying there's evidence that somebody else was using it with him?
I don't think there was any evidence one way or the other, Judge, except for the clothes and the products that I think clearly show male and female usage and occupation of it. But moreover, if he had been arrested, some of the cases they talk about, well, there's a case that the state cited in which well, I can't find the case, but there they say it's a case, it's Poindexter. Poindexter was the only person in the house, and they said it's crucial testimony in that case that he was the only person associated with that house, unlike our case, which we've got 6 and then just 2 minimum of the bathroom. So how can we say it's affirmatively linked to Meyer, that it was in his plain view when there's just no evidence of that? It's just no evidence it was in his plain view. The other thing about the cases cited McGoldrick. The prosecutor cited McGoldrick. At McGoldrick, he was in a truck with 600 pounds of marijuana, and the state said, well, the officer could smell the marijuana, so could McGoldrick, and there was no partition between the passenger section and where the marijuana was. And the Court of Criminal Appeals says that you can't impute the smelling ability of the officer who said he smelled the 600 pounds to the defendant, because we have no evidence of that. Just like that, we cannot impute that John Meyer ever saw that, or that if he saw it, then he knew what it was, because it is crucial to say that the police officer himself said, I didn't recognize that blue stuff as anything illegal. The experienced narcotics officer and the chemist said it's relatively rare to have blue methamphetamine. So going back to the Hawkins case, where Justice Rios said that one of the things they have to prove is that the substance was methamphetamine. Where's the proof of that? Real briefly, Your Honors, the other cases they cite, Tate, we talked about Tate, Hawkins, we talked about, and Torres. Let's talk just briefly about Torres. Unpublished case with no precedential value from Houston, but there they found almost $1 million of cocaine in plain view in the kitchen of the house. And they noted that Torres was seen walking up and entering the residence without knocking. That's pretty strong evidence that if you have $1 million of dope in your house and you can walk in without knocking, that you know something about that dope. Nothing like that. Nothing like that in our case. As I said, Your Honor, I would welcome, the prosecutor last night submitted several cases. None of those cases are like ours. I would welcome, I wish he would file another set of authorities, additional authorities with this court, which support his position, because I can't find the case. Briefly on the statement. I thought it's interesting to note that nobody saw that nod the first time around. It was only seen. And so what the case is, Joseph and Butler says that the prosecutor's burden is great, but at least in some cases, waiver can clearly be inferred. Judge Boyd said it's a very slight nod of his head. It's very subtle. It's our point that even if there was a nod, that does not meet the very heavy burden, the great burden that the state had to prove waiver.
And the state just said they don't need the nod. Do you agree with that?
I don't agree with that at all, Your Honor. I don't understand his point about, although I do agree that the statement seems to cut in our favor on the affirmative link, but I don't see that at all as satisfying your very heavy burden, the great burden of showing waiver of intentional, knowing, and voluntary waiver of your Fifth Amendment right.
Thank you, Mr. Stevens. I thank all counsel here. It's been a very good oral argument, and it's the rare occasion that we get the trial lawyers or those who tried the case up here arguing here in oral argument. So I've been very impressed, and your case has been submitted, and you will be notified when we have an opinion for you. Thank you. You're adjourned.